till 69 actually we are done. So questions were already dealt by Nishant sir and very well explained as well. So now we are going to discuss the rest of the questions. Actually, it's 70 to 84 perhaps. So there are 32 questions, I think. So the next passage, all the questions are based on the passages as we know. But the thing is that unless we know the basics, sometimes actually even passage can be missing on something. And the thing is that even to read a passage, especially actually when the subject of the passage is law, you need to have some understanding of law, at least the approach actually, what we adopt in laws specifically, that what exactly there is a commonality, you can say that whatever is the law, whether it be criminal law, civil law, whatever actually, any subject matter on which actually we legislate. So we want to actually address some problems. Either actually there are some facts, we see that actually those facts are not good, we have to address those social facts, or we have some purpose, some plans, some objectives to be, you can say, to be considered as some ideals in the society. So for that purpose, we make some law. So always while reading a passage, you have to focus on that particular thing. What exactly is the law? What it seeks to address? And normally in a passage also, you can say that there are things actually, the way the passages are, you can say, formed, we take care of this particular aspect. So to test the legal reasoning of the student, it's not about the testing the knowledge of the student, because you are not yet lawyers, you have not done your LLB, LLM, whatever. So you have not yet gone through that. But at least whenever you read, so whatever law actually, even in your classes, actually you are taught some laws, some provisions, not to make you memorize all those things or learn things by rote, but rather to understand what is the approach of law, so that you can reason well when there is a question, you can say, of application of law, when there is a question that whether what exactly is being said, and if there is a scenario given to you, what exactly would happen, how that law would be applied, and what will be the consequence, what will be the outcome of application of that particular law to those facts. So going by this approach, actually we have to read the passages, and then the questions actually on those passages we have to deal with. So this passage, this is obviously, it's very clear that so many GI terms are there. So this passage is on geographical indication. As we know that if you know beforehand that what geographical indication is, and then how actually we want to protect it, what is the relevance of its protection, why we want to protect it, it's very easy. But still we have to go through the passage. So the passage is, I'm not going to read it word by word, but still. So geographical indications are form of intellectual property that designates a product as originating from a specific geographic location, where a given quality, reputation, or other characteristic is essentially attributable to its geographical origin. So why it's geographical indication? Because it indicates that geographical location, geographical region from which that particular product originates, and that's what we want to protect. Like if you have heard of almost, I think that there are almost 600 something, it's almost around 650, I think, that those many geographical indications, GIs, are registered in India. And recently, you must be knowing that there are many such examples, basmati rice, many other things. So it's attribution of the qualities, properties to a particular geographical location or origin. It's of geographic origin. GI protect names that are used to identify products with the specific qualities or characteristics due to their geographic origin. For example, champagne refers to a sparkling wine product in the Champagne region of France. Champagne is a district. And Darjeeling tea, again, you know that Darjeeling is a particular city, place, whatever. So, in the chicken neck of Bengal, refers to the refers to tea grown in Darjeeling region of India. The protection of GI ensures that only products genuinely originating from a specific region are allowed to use the geographical name. So, if someone who is, you can say, cultivating tea in other regions of India, he can't sell the same tea with the name or with the label or with the misrepresentation sort of thing. They won't be able to claim that yes, they are selling Darjeeling tea, because only when you are cultivating that tea or the tea coming from Darjeeling belt of India, only then it can be considered to be Darjeeling tea, and that GI is there. What does it mean? That when GI is there, it means that only the tea originating from that particular geographical region can be sold with that particular label, or you can say with that particular mark or whatever, if it's to be anyway to be given the impression among the customers that yes, this is a Darjeeling tea. So other people won't have that right. It would be considered as violation. It's so obvious. This helps. Yeah. So after that, the protection of GI ensures that only products generally originating from a specific region are allowed to use the geographical name. This helps maintain the product's reputation and quality, prevents misuse or imitation, and supports local economies by promoting regional products. International agreements such as the TRIPS agreement under the WTO, World Trade Organization, provide a framework for protection of GI globally. In 1995, actually, when WTO actually with this TRIPS agreement, which was specifically, you can say that attributable to, or especially it was related to the intellectual property things, whatever you can say, there are many of that sort, like trademark, copyright, and all. So all are sought to be protected in an international way. So it's irrespective of that whether you have the legislation or not. So you are supposed to have some legislation, some statutes in order to protect all those things, and the protection is to be given globally. So this was the purpose of TRIPS agreement. So you can say that just after reading the passage, we must be able to know at least what exactly geographical, what is it seeks to protect, and how things can be, you can say, violated. What are the duties, rights given under the statute to the GI products, how it can be violated, and what can be the consequence. So you can understand that. So based on that, there are some questions. I think very obvious questions are there, easily inferable from the passage. Which of the following statement, question number 70, which of the following statement about geographical indications is not true? So you can just read, GIs are protected under international law, ensure that only products from a specific regions can use the GI name. The use of GI name can be legally challenged if it is used by products not originating from the specific region. Can be legally challenged. Of course, it can be legally challenged, but where, what is here, which is not correct? The first one seems to be correct. Second one also, because it can be legally challenged. Geographical indication can be used to any product which is licensed regardless of its place of origin. Again, you can just mark it for the time being. I'm not saying that whether it's right or not, but at least by the passage, whatever understanding you have taken from the passage, you can, based on that, you can see that this can be the right answer. The TRIPS agreement under WTO establishes a framework for the protection of GI on a global scale. Of course, third C was right. But apart from that, if you contrast it, all other options actually given, those are very, you can say, easily it can be said that these are obvious impressions from the passage. So C is the answer. Very easy. So it's not that a lot of reasoning is going to be applied. It's so obvious that geographical indication can be used to any product which is licensed regardless of its place of origin. So place of origin, or the geographical region from which a particular product originates, is the most important thing. This is the basis on which geographical indication can be granted. So C is the correct answer. 71. If a product named Darjeeling tea is produced outside of Darjeeling region, which of the following legal actions is likely to be taken under GI protection laws? A. The product can still be sold, but with a disclaimer about its true origin. It's primarily actually in violation of the law. That GI product, it would be misleading, because only when a product originates from a particular region can be termed that yes, this is a Darjeeling tea or a Banarsi sari sort of thing. If a product originating from any other region can't be termed as such. The use of GI name Darjeeling tea can be legally contested and potentially prohibited. Of course, it can be done. The product can be sold under different GI names of not Darjeeling tea. Again, it's not given. So direct inference is B only. The product can be marked as Darjeeling tea and will face no legal consequence. Of course not. So the very first thing is it must originate from that particular geographical region. So here the option B is correct, because it can be legally contested. Once there is a right that yes, this product only can use the name Darjeeling tea just by the reason of originating from that particular region, so other can't use that. This is what is the purpose of law. So of course 71 B is the correct answer. Which of the following is not a potential consequence of the misuse of geographical indication? A. Loss of consumer trust in the authenticity of the product. Decrease in the market value of GI protected product. Compulsory license on the patents of the misusing entity. Potential legal action of infringement against the misuse. Is not a potential consequence of misuse of geographical indication. Of course, potential legal action can be there. If there is no law, in that case also there is a loss of consumer trust, because it won't have the same quality of the product which is genuinely originating from that particular region. B. Decrease in market value of GI product. Of course, there would be decrease, because other products in the name of the same, you can say, it would be passed off to the consumer, and in that case they won't be actually getting the same quality, and of course the name, and there would be a kind of bad repute for the very reason. So compulsory license on the patents of misusing entity. Compulsory licensing is not the thing which is used in GI thing. So C is the answer. All other things are very obvious, that yes, of course, there is a loss of consumer trust, market value would be decreasing, and potential action, of course, is there under the GI Act. Yes. Next question coming to this. In the context of GIs, which of the following scenarios best illustrate the concept of geographic origin? The product's name is changed to reflect its local ingredients rather than its place of production. The product is marketed with GI name even though it's produced in different region and country. Product is identified by GI name that corresponds to the region where it is traditionally made or cultivated with distinctive qualities due to that location. A product is sold under a generic name with no reference to its production location. So in the context of GI, which of the following scenario best illustrates the concept of geographic origin? So when it is illustration of geographic origin, when that product is associated with a particular geographical region, and by the reason of that, it has some unique property. So that particular region is giving it a particular property or quality just by the reason of that. So what would be the correct answer? C, obvious. Is there any doubt? I don't think. Because all other, or you can say the very first option, it's saying that irrespective of that particular location, it can be given any other name and then sold. Another option is that even though it's produced in different region and country. So of course, it can't happen. It's not valid argument. D, a product is sold under a generic name with no reference to its production. Then there is no use of GI at all, because when it's used like tomato, where does it come from? So whether it's coming from Nasik, or you can say any other region of India, that is not there. So just by the reason, it's not reflecting any geographical region in the name, in that description there is no such geographical name. So of course that won't be a right answer. It's very obvious again. I think that this year's legal reasoning section can be termed as the easiest one. I think it's not even moderate. Okay, the next question, 74. Choose the most appropriate objective of TRIPS agreement concerning geographical indications. Most appropriate objective. Of course, objective is to protect GI across the globe. So because TRIPS is an international agreement. Of course, we have our national laws, municipal laws to protect that, but under TRIPS, actually, all the countries who have ratified that particular agreement are supposed to make such laws, legislate on that particular subject, and then protect it. So, again, the options we are going to read: to harmonize intellectual property laws across member countries, to ensure uniform product labeling standards globally, to provide a framework for the protection and enforcement of geographical indication among WTO members. Of course, specifically referring to geographical indication, and especially among the WTO members. Who all are WTO members? Only the TRIPS is for them. So here again, the correct answer is C. Again, it's very obvious, I think. Now coming to the next passage. This is a burning topic, as we know. That the NEET controversy, that how actually even there was a lot of hue and cry regarding that particular examination, how it was conducted, and it's not very new thing in India, but before that also we know that prior to this NEET controversy, there are many examinations, many competitive examinations, specifically when we have gone through such sort of, you can say, problems, that unfair means, then question out, leakage, many other things actually that need to be curbed. So of course, keeping that in view to address this particular problem, this challenge, the parliament has come up with a law. So public examination, and what actually it's obvious that whoever are, you can say, are the stakeholder in that, whoever are facilitating the conduct of examination, whoever it may be, whoever are the stakeholder, even it's a big organization who is providing that particular service through online, you can say, paraphernalia and others, actually human beings, actually human resource they are employing to that. So all those people, actually whoever are there, if they are caught to, you can say, caught to be indulging in any sort of illegal activities, unfair means, actually they are somehow encouraging it, so in that case they must be held liable. So this is the purpose. Actually one can understand, if you are just, you have gone through many laws, actually even the basic things, actually you must have studied contract law, basic principle of criminal law and all, so at least this much you know. But of course, we are going to read this passage to answer these questions. So, public examination prevention of unfair means, as it is obvious in the title itself, that has provision for up to 5 years imprisonment. So, it has the punishment up to 5 years imprisonment. So now it's coming to, it's, you can say, a different fact that actually who are going to be punished in what manner. So that's different thing, but the punishment, the maximum punishment prescribed by the law or the act is 5 years, and up to 1 crore for malpractices and organized cheating in government recruitment exams was notified by union government and came into effect from June 21 to 24. The bill has received assent from the president. As we know that before that it's just a bill, unless it has got the assent from the president, it's not a law. The public examination prevention of unfair means, and always be meticulous. Whatever is actually given in the passage, actually we have to take note of that. You have to be very conscious, and if you are conscious while reading, if you are reading actively, the two things you can say, the passive reading and active reading. So here actually you have to take the questions. So of course you have to be very active while reading it, and again you can say while going to the going through the questions also, you can again resort to the passage, but still one reading is enough. I think it's not that a big deal, and it's not a very complex one. So Public Exams and Prevention of Unfair Means Act 24 mentions punishment for leakage of question paper or answer key, directly or indirectly assisting the candidate in any manner unauthorized. So what are the, you can say, here scenarios are given that what can be the violation. So leakage of question paper or answer key, directly or indirectly assisting candidate, whoever, or in whatever way, directly or indirectly, through electronic means, manually, through anything, actually by interfering into the, you can say, the overall, the conduct of exams and the way it is to be conducted. So that can be, that can attract, you can say, punishment over there. Tampering with computer network, computer resources, so electronically also, if you are interfering in that case, you would be held liable as offense done by a person, group of person or institutions, whatever, in group, team, institution, individual, everyone can be held to be liable. Besides this, these creation of fake website to cheat or for monetary gain, conduct of fake examination, issuance of fake admit card or other letters to cheat, or for monetary gain and manipulation in seating arrangement, allocation of dates and shifts for the candidates to facilitate adopting unfair means in examination are also among the offences punishable under the law. So, of course, all these things are to be, are sought to be punished. Any persons, no, coming to the provision, as it is an inverted comma, any person or persons resorting to unfair means and offences under this act shall be punished with imprisonment for a term not less than 3 years, not less than 3 years, but which may extend to 5 years. So what does it mean? That if there is a particular punishment in a particular case, somebody has to be punished. So he can be punished with 4 years of imprisonment. He can be punished with, you can say, fine up to 10 lakhs, mean it can be 5 lakhs as well. So a service provider, so this is for anyone, a service provider specifically it is given. So we have to take note of this. A service provider engaged by the public examination authority for the conduct of examination shall also be liable to be punished with imprisonment of a fine up to 1 crore. So here the figure is different, and proportionate cost of examination shall also be recovered from it according to the act. So such service providers shall also be barred from being assigned with any responsibility for the conduct of any public examination for a period of 4 years. So that too would be appended. That apart from those punishment, actually he would face such deprivation that he won't be able to conduct examination for the period of 4 years. So now the questions we are going to 75. A bill becomes an act only when it's so obvious. I don't think that there is any requirement to read the passage to answer this particular question. Anyone, even a novice in the field of law, whoever you can say, even some GK sort of thing, polity, who is just knowing the basic polity things, basic fundamentals of Indian polity, he would be able to answer this question. So it's very obvious. I don't think that if I am answering this, then I can claim to be an expert. Of course, so it's so obvious. So both the House of Parliament passed with simple majority. Of course, it has to be there, but it's not the final stage. Both the House of Parliament passed with absolute majority, whatever. So depends on many other things. When the Prime Minister of India gives his approval, nowhere it's mentioned. Prime Minister is none in this particular context. When the President of India gives the assent, so Parliament, as you know, that it constitutes Lok Sabha, Rajya Sabha, and the President. So Lok Sabha, Rajya Sabha, of course, both the houses passes it. So after that, the final thing is this. So unless the President's assent is there, it won't be an act. So this would be the answer. Next, a service provider engaged by public examination authority for conduct of examinations indirectly helped his family member by giving hint on questions that were supposed to be asked in the examination shall now punishment, as we have already gone through, be liable to be punished with imprisonment of a fine of 1 crore, be liable to be punished with imprisonment of a fine up to 1 crore, of 1 crore up to 1 crore. Of course there was up to 1 crore, but this is not the right answer because you have to see the best option. Be liable to be punished with imprisonment of a fine up to 1 crore and entire cost of conduct of the examination. Here again, what we have to take note of is this term. Entire was not used over there. You can refer to it, but once I think that one reading is enough. So you can even be able to recall that because it's not just that much time. Even you can say the recency effect is already there. You have just read that with focus, with attention, with so here entire is wrong. So it was proportionate. So here what would be the correct answer? Because all the three, they are not correct. So the answer is D, none of the above. Coming to 77. An invigilator of a public examination found guilty of manipulating the seating arrangement to favor his relative writing the public examination is punished by the court. No, he is not the service provider. The very first thing you have to, so there can be many stakeholders. So here we are talking about invigilator. Which among the following is the appropriate punishment as per the punishment mentioned in the above passage? So what was the punishment for other people? So imprisonment for 1 year and fine of 1 lakh, it was not there. So altogether, this figure actually we didn't see over there. Imprisonment for 2 years and a fine of 10 lakhs. Of course, it was not there. 2 year, no mention. 3 year got a mention over there. Imprisonment for 3 years and fine for 15 lakhs because 15 lakh figure was not there. So again, this is not the right answer. So right answer is imprisonment for 4 years because minimum 3 and maximum was 5. So 4 years can be there and up to 10 lakhs fine was there. So 5 lakhs, it can be a valid punishment under the law as prescribed. So this would be the, here actually we have to take inference. This is not directly we can see in the passage. So direct, this figure was not there, but from 3 to 5 we can infer 4, from up to 10 we can infer 5. So this way we can, so this is simple. You can say that this is very basic level comprehension is required. So everybody can understand this. So this was the correct answer. Now coming to 78. Identify which of the following is not an unfair means relating to the conduct of a public examination. Of course, we have gone through the passage and we must be able to understand what exactly is to be termed as unfair. So A, coaching center conducting mock test for students. Of course, it's obvious that it won't be an unfair means because before the examination, there is no examination at all. And before the examination, you can prepare anyone. Of course, we are into this. So of course, this is not the thing which is sought to be prohibited by the act. So obviously A is the answer, but still we have to go through the other options as well before we mark it. So B, coaching center offering help to students during the examination. Of course, it would be unfair. During the examination, none can extend help to anyone, especially the students. So, but this help, it's not mentioning the what kind of help, but still it's obvious. So it won't be there. The center superintendent of the public examination on the request of the coaching center provides seating arrangement of all sits in one hall. Again, it would be unfair. It's promoting that a group is having some conducive group is there so that each other among the group in the group can help extend help to each other. So D, Central Superintendent of the Public Examination indirectly assisting the candidate. Of course, all are obvious again. So in this question, the answer is yeah, last question of this passage. Who among the following is not a service provided in the provided in the context of a public examination? So service provider. Of course, when the examination is being conducted, whoever, whether it be that someone like as you know that what was the name of the NEET conductor? I'm not able to recall that. Rotenix, perhaps it was the name. So a coaching center which prepares students for passing in the public examination. Of course, like previous question, it has similar sort of options, not a service provider. So coaching center which prepares a student for passing in the public examination. Prepares, not, it's not something you can say that it's extending help or something. And it's about the examination, conduct of examination. So it's not relating to the conduct of examination at all. So coaching center, of course, this is right answer as obvious from the context. But still, we have to read other options as well. So B, printing press, where the question paper of the public examination is printed. Of course, it's providing a service in the for the conduct of examination. It's printing the question for the that particular, you can say, commission or whatever, whoever is conducting that examination, that authority. In our case, you can say that in CLAT, like the CLAT consortium, actually, they are the ones. So if consortium is having an agreement or contract with the, you can say, printing press for printing of the question paper, and that press is, you can say, anyhow it's involved in any sort of, you can say, leaks that particular question paper to anyone before the examination, in that case it would be held liable. So printing press is a service provider in the conduct of examination. The software company that manages the website of the public examination, of course they are conducting the examination, they're extending the support, help. D, the company which scans the OMR sheet of the public exams. Of course, they can manipulate sometimes, you can say. They can change the answers or whatever. They can give a wrong data that yes, this particular student, that student could have scored 90. They can say that it's 95. They can manipulate with it. Of course, they can be held liable. So all these three, you can say, these three are service provider. So this is not. So this is the answer. So A is the correct answer to that. Now coming to the last passage, I think this is the last one. Question number 80, passage number 50. So the Supreme Court of India declared that right to privacy fundamental right. Again, we know the right to privacy, and of course, you can say burning thing has been crux of discussion among the, you can say, the people, especially who have interest in law, who consider themselves to be having a say, even among the general people. And in legal parlance, of course, this was burning topic. This was primary thing, especially in the constitutional realm. Specifically, it was discussed with a lot of zeal. So the topic is this only. The Supreme Court of India declared that right to privacy is a fundamental right. Of course, this right is part of the, or you can say this emanates from the right to life, that the right to informational privacy is part of this right. Subsequently, the Parliament of India enacted a new law relating to digital personal data protection. As we know that very recently this act has been passed, 2023 Act. The law applies to Indian residents and businesses collecting the data of Indian residents. It also applies to non-citizens living in India whose data processing is in connection with any activity relating to the offering of goods or services that happens outside India. The laws allows personal data to be processed for any lawful purpose. If the personal data is sensitive, then additional safeguards are to be observed. The entity processing data is sensitive, then additional safeguards are to be observed. The entity processing data can do so either by taking the concerned individual's consent or for legitimate uses, which include situations where an individual has voluntarily provided personal data for a specific purpose. The law requires that an individual's consent must be free, specific, informed, unconditional, and unambiguous with a clear affirmative action and for a specific purpose. While reading that, you must be able to see that the law of contract or its essence is reflecting over there. But when regarding anything, if you have contracted, if you have given consent to something, it can be used. So of course, it's a matter of contract. When there is no contract, of course, you can say that it can be regulated by general law, but it has also some aspects of contract, because two people, two individual, two, you can say, private persons are involved in this transaction. So law requires that an individual's consent must be free, specific, informed, of course. The data collected has to be limited to that necessary for the specific purpose. Of course, everything has a purpose. So you are providing something for a particular purpose. You can say that regarding your health, some data is there, your age, or whatever you can say, you are providing to your doctor, your general physician. And if he is using for another purpose, it's of course, it's not, it doesn't seem that it's very obviously, you can say that anyone with a, you can say, common average intelligence, average morality can say that no, it's not good, because purpose was altogether different. But of course, in this digital era, it's very easy to, you can say, have some data. In old, you can say, days, data was not stored the way it can be done. It's easily can be stored, easily can be shared. It's not that hard copies or the file, or we can say the things, you can say, from a big warehouse can be shared, but just a click on a mouse and you can say that you can share even innumerable number of things to any other person. The law also creates rights and obligations for individuals. These include the right to get a summary of all the collected data and to know the identities of all the entities organized with whom the personal data has been shared, along with the description of data shared. Individuals also have the right to correction, completion, updating and erasure of their data, of course. So I want that the data after that particular use under the contract, I don't want that data should remain with that particular person or authority or the organization. So I can even do that. I have the right to. Besides, they have a right to obtain, even you must be knowing that right to privacy, or it includes even the right to be forgotten. So you don't want that those things should be there. And once the purpose is realized, you don't want that particular thing to be there. Whatever, if for that particular purpose, anything was to be used as a means. Besides, they have a right to obtain redressal for their grievances and right to nominate person who will receive their debt. So these are the rights. They have the right to obtain redressal for their grievances and right to nominate persons who will receive their data. So you can also have a legal representative in that case. So now coming to the questions. So the passage was all about the rights under this particular act people can have. So an Indian company collects personal data from its user to provide personalized services. The company intends to share this data with a third-party vendor for targeted advertisement. Under the Digital Personal Data Protection Law in India, what must the company do before sharing the data? So it's personalized services for that particular company has collected that data. And company intends to share the data with a third-party vendor for targeted advertisement. Of course, even the purpose is foreign to that. So the options we are going to read. A. Obtain explicit consent from the user. Share the data. B. Share the data by informing the users as it is for business purpose. Encrypt the data and share it with the third party vendor. Inform the third party vendor that the data is sensitive. No, nothing at all. So you are no one to do that. So you will be informing that it's sensitive and it's used for this particular purpose. It's altogether you are prohibited. So A, before there is a consent, until the user has given the consent, you can't use that particular data for any other purpose. So the answer is A. Law is very clear on that. Question number 81. A social media platform processes user data based on consent given during account creation. The user now wishes to withdraw consent to process their data. Under the Digital Personal Data Protection Law in India, what must the platform do? So yes, so in this case, refuse to accept the withdrawal request since the consent was already given. Comply with the legal requirements and stop processing the data. Continue processing the data but notify the user data based on consent given during account creation. The user now wishes to withdraw consent to process their data. So once consent is given, it's not that something one time affair, but it's a, you can say, continuous process. That's why when we apply our reason, we can get the answer. Under the Digital Personal Data Protection Law, what must the platform do? So what it must do? Refuse to accept the withdrawal request since consent was already given. Can this be the answer? comply with the legal requirements and stop processing the data, continue processing the data but notify the user, allow withdrawal only after 30 days. There is no such mention. So what could be the correct answer? Comply with the legal requirements and stop processing the data. It's so obvious because all are, you can see that very seemingly they are obvious that those options can't be the correct answer, and nowhere actually we can infer this from the passage. Question number 82. A financial institution collects biometric data from its clients for verification purpose. If the clients wish to know that data has been collected under the Digital Personal Data Protection Law in India, what right allows them to request this information? So rights regarding what? The biometric data which is there with the financial institution. So of course, even terms we can just analyze. So A is right to data portability. Nowhere portability is nothing of that sort actually. It doesn't suggest something convincing. B, right to correction. There is no such matter. It's not that something is wrong and it's to be corrected. Right to access. Right to be forgotten. There is no such request because here the request is what right allows them to request this information. They want information. So obviously the right to access would be the correct option. Question number 83. A startup provides a health tracking application that collects sensitive health data from users. Under the Digital Personal Data Protection Law in India, what additional precautions must the startup take compared to regular personal data? So, what would the correct answer? A startup provides a health tracking application. So, it may collect some sensitive data because health tracking. So, all the indicators you can say regarding person's health, whether it be blood pressure, you can say its fluctuation, whether it be any other thing, whether it be something regarding the blood sugar level of that particular person. So within a particular period of time. So everything is very sensitive. So under the Digital Personal Data Protection Law in India, what additional precaution must the startup take compared to regular personal data? Because those are very sensitive things. So no additional measures are needed. Is it so? Not, of course. Ensure explicit consent and adopt higher security standards. Store the data only with government agencies. Store the data only with hospitals and other healthcare institutions. No, even it can't be allowed to share that data with other healthcare professionals or institutions as well because it's sensitive health data from the user. So you can see that ensure explicit consent and adopt higher security standards. This is the duty on that particular health tracking application. It's not open for them to share that data to any other hospital or healthcare institutions. Now the last question. As per the passage, what are the rights included under the Digital Data Protection Law of India? So one by one we can check and finally we can answer this. Right to get the summary of collected data, of course, right to access includes this. Right to know to whom the data has been shared, of course, that too, because data is his, he is the owner. Right to correct and update the data. Of course, if some wrong data, sometimes you can see that casually you gave some wrong information and that was stored. So of course, you want it to be rectified and that is always your right to get it rectified anytime whenever you wish. Right to get the data removed from the database, that too, of course, because as we know, the right to be forgotten. So if once that use is an, or you can say that I have changed my mind, I don't want the same service to be service from that particular institution, that particular service provider. In that case, even I can tell them that yes, my data or whatever my records are there, that's to be erased, removed from that particular database, right? To decide on who can receive their data. Of course, that too, we have already gone through the similar questions were there, right? To get redressal of grievances. That too is always there. Whatever grievance they have, they can ask for the redressal of that. It was there in the passage itself. So of course, the correct answer is, I think, none of them, none of the right, you can say, is not there. So all the rights feature over there in the act. So finally, the answer is D. All the rights are there. So we have come to the end of the question paper. And I think that the way I have explained it to you, it must be of some help. And it also gave you the, you can say, final status, and you can match your answers with the question, with the answers given by me. And then, of course, it was very easy. It was one of the easiest paper I think I have seen. One of the easiest. I'm not saying this is the easiest one of the easiest. So, easiest paper. So of course, you can't afford to make silly mistakes because all are based on the passive, and passive was very easy. It was not, it was very lucid sort of. It was not an obscure one. So of course, a good score can be somewhere around 29, 30. Actually, silly mistakes sometimes can happen, but I think that even one or two questions hardly I can make out that would have sometimes would be considered to be misleading you. But other questions are direct from the passage. There is no dilemma, there is no confusion regarding that. Always, I think that making mistake is not at all, you can say, a welcome gesture in this kind of question. So this is all for today. All the best for the result. We will be meeting again very soon with some other topics, some discussions regarding the concepts actually. So